is currently a growing trend among countries around the world to abolish death penalty from their criminal law system. This trend has triggered the United Nations to ban the use of death penalty through the resolution in December 2007. But then, even though there are lots of countries who have already abolished death penalty, and the UN has also declared the abolition of it, there are still several countries who use death penalty as one of their existing criminal sanctions. Article 28 of the Indonesian Constitution stated that everyone has the right to live and preserve their life. The right to live originally could not be found in Indonesia Constitution, whether it is in UUD 1945 or the current Constitution, Republik Indonesia Serikat's Constitution, or even the Indonesia Provisional Constitution 1950. This right was first introduced in the Constituent Assembly report, which then adopted in Indonesian Constitution amendment. Death penalty in Indonesia during this period was used as a strategy to stop rebellions and a means to defend Java from attack from Britain. Death penalty under the Wetboeken Strafrecht for Indies in 1980 was used to maintain discriminative racial perspective and to preserve public order. Death penalty during the period of 1945 until 1949 was used to continue Dutch colonial footsteps and to strengthen the national state defense to face war. During 1949 until 1959, the death penalty was used to prevent rebellions. Within the period of 1959 until 1966, it was used to keep the national stability, to secure the revolution period, and also to make sure that the government economic and development program could run without any disturbance. During the period of 1967 until 1999, death penalty was used to 1. Assure the political stability of the state to secure the development agenda. 2. Maintain the image of the government in front of international communities. 3. Assure national security. While in the period of 2000 to 2017, the death penalty was mainly used to show that the state cared about victims of crime, to support the campaign against several crimes such as drugs, sexual offenses, corruption during disaster, terrorism, and lastly, to keep the national stability of the state. Up until October 2017, 18 people has been executed. Based on the latest data dated 9 October 2018, 2019 people are on death row in Indonesia. Indonesian government claimed that in all cases of death penalty, fair trial principles always been enforced, but in our research we found otherwise. Indonesia's criminal procedural law is still unable to assure that every defendant charged with death penalty has the access to an effective legal defense. It still sees death penalty cases as regular cases. Thus, there is no special right given to the defendant. The fulfillment of right to competent interpreter in Indonesia can still be considered as weak. The indecent regulation of this right affects the compliance to fair trial principles, because this right is one of the fundamental rights to make the defendant understand the whole process they went through, so they could prepare the defense well. Poor access and quality of interpreter in death penalty cases have caused violation of fair trial rights of the defendants. For example, the right to information about charges, right to know about evidences used against them, right to question prosecuted witness, and other rights. This violation was found to happen in Mary Jane and Rodrigo cases. The fulfillment of right to freedom from torture and ill treatments can also be considered as weak in Indonesia. Based on ICGR research, 12 defendants from 11 cases has claimed that they were tortured and threatened during interrogation, not only towards the defendant, Torture has also happened to witnesses. There is no decent regulation about this right in Indonesia. It shows in first, the unavailability of regulation regarding the responsibility to monitor place of detention and to give decent place of detention to prepare defense. Second, the unavailability of investigation system regarding the defendants or witnesses' claim of torture and ill treatment. The criminal procedural law of Indonesia still allows the use of evidence which illegally obtained, and there is no regulation about exclusionary rules in it. The use of witness from the officers conducting interrogation and crowned witness is still allowed according to Indonesia criminal procedural law. Not only that, testimony from defendant that was threatened during the interrogation can also still be used. This condition shows that Indonesian procedural law does not strictly regulate decent procedure on how to obtain evidence lawfully and the regulation on how to know whether an evidence is legal or illegal. The right to not be executed in certain conditions in Indonesia is also not corresponding to international standard. In Indonesia, pregnant women, women with toddler, and elderly people could still be imposed with death penalty and be executed. Consideration on should certain people be executed or not then will be made through a court decision, based on the condition of the defendant who can be used to alleviate the sentence. The decision not to impose the death penalty of the accused in a certain category is still based on the judgment of the judge and is not an obligation.